We're on.
Okay, we're on the record in case number D216266861D, Flaxman versus Flaxman. May I please have appearances beginning with Mr. Smith?
861D.
Yes, thank you.
Flaxman.
Good afternoon, Your Honor. It's Radford Smith on behalf of Michael Flaxman, who's here and present of the Blue Jeans video.
All right, welcome. Mr. Fleeman.
You went fuzzy, Jack.
He's froze.
Yeah.
There we go. Mr. Fleeman, are you back with us? Nope.
Good afternoon, Your Honor. I'm not sure.
We've lost you at that point, sir.
Yeah, I turned off my camera because it might work better. Can you hear me now?
I can hear you now, sir.
Okay. Jack Fleeman, bar number 10584, on behalf of Melissa Flaxman, who's also present via Blue Jeans, Your Honor.
All right. Today is a status check on whether or not we've got a stipulation. Are we close?
We have a stipulation, Your Honor. I mean,
Yeah.
there's no question we have a stipulation. It's in writing.
Really?
So we got a stipulated parenting plan. Yeah.
Well, we have the parenting plan. What about the rest of this, or do we need to set an evidentiary hearing?
No. Well, look, if Jack is going to insist that we do so, I would suggest this, that there is already a written agreement addressing both support, attorney's fees, and division of property. So if we're going to do that, why don't we just prove it up today if we're going to have an evidentiary hearing? Because there's really no point in this. We've agreed on everything. In fact, while we were waiting, Jack and I took the time to address some emails and see if we could work out some of the other issues. Frankly, if you can take 15 minutes, Judge, we can ask you a few questions. You can probably help us get it done today.
Okay.
I don't want to look, it's your time. I don't want to insist on that, but it might save us another hearing.
Well, I'm running just a little bit behind, but I will take whatever time that y'all need if it will help.
Well, okay. Let me say this.
Mr. Fleeman, do you agree? Did we lose Mr. Fleeman? Yep.
So there
My
we go.
connection's gone horrible for some reason. I'm trying to reconnect it to a different line right now. Can you hear me now?
I can hear you now, sir. Do you agree with Mr.
Yes, I know
Smith
we're on
that
the
I
first
may
one.
be able to help for on a couple of things?
You might be able to give some direction. Yes, I couldn't exactly hear everything that he said. I don't know if you said something. He said something about a prove up.
He said we could do
I
a
don't think we're
prove up.
prepared for that today, but direction would be beneficial on a couple of issues.
Good. Why don't I give you some directions and we set this out for 45 days or so?
That sounds fine, Your Honor. Let me just go over, Jack. I'll just raise the issues that, in my understanding, where the parties are. I sent those over to you today. If there's anything else, please let us know. And so, Judge, here's the issues that I saw when we were addressing it, and a couple of these I think we've resolved. Okay, so there's health insurance that needs to, and I'm just going to go in that order that was in my, Jack, that I sent you this morning at 9:42. You have that? Yeah.
Hold on. I can't hear you. I'm trying to restart.
He's talking about an email from 9:40 this morning. Did you receive that, sir?
Yes.
Okay, good.
I'm not sure of the time, but I did receive an email this morning.
Yeah, it's okay.
Okay.
I'm just looking at the email. All right, so the first issue is health insurance. The parties have agreed to divide the cost of health insurance for the party's daughter. That's in the parenting plan that the court has already ordered. But we advised that the premium is $227.60, and Mr. Flaxman has indicated that he provided that information showing from the broker showing that was the amount. And so if Mrs. Flaxman needs that information again, we're happy to provide it. And we'd indicated, or Ms. Flaxman indicated that she would want Mr. Flaxman to pay the premium and then get reimbursed by her on a monthly basis. She did raise the question as to whether or not this would be a deduction for him. The court probably knows this because it ran its own business for a lot of years, but you don't get to deduct the premiums for health insurance unless they're more than 7.5% of your adjusted gross income, and this ain't going to be that. So no, there won't be any deduction. I mean, whether he takes it as something on an LLC that he operates his business at, I don't know. But there's no viable deduction that I'm aware of for health insurance. So it becomes income if he takes it as an expense. So in any event, that's our position, is that it just should be the 227.60 or whatever, the proof shows.
So they are going to equally divide it in accordance with the parenting plan, or they're not going to divide it?
Well, they are. I mean, that's our position. I don't know if Jack has a different one. I don't think he does.
No.
Well, Your Honor, it was not discussed at the settlement conference, and at that point, honestly, I wasn't aware that it was in the parenting agreement. I do agree that it is in the parenting agreement that they're going to split the premium.
Okay.
I think that was signed with the understanding is that is what the court generally does, is splits the premium between the parties.
Okay. Yes.
I would not have necessarily agreed to that, but it was in the parenting agreement. So.
Okay.
Okay. There we go. One issue down.
One issue
Thanks,
down.
Judge. Okay. The cell phone is, it's, Jack, I learned this after I sent you this email just a few minutes ago, but Mike says that it's just Melissa and the daughter on the plan. So it really doesn't really need anything, does it? I mean, there's the total cost of the plan is $310, but if she's going to pick up the plan, and then whatever the line it costs for is for the daughter, he'll pick up half of that and provide it to her. Does that make sense? Yeah.
Repeat how it's going to be done, because we talked about it in the email, and you're saying there's something different.
Well, I'm just saying that I was under the impression when I sent you my email back that Mike was on the plan, but he's not. It's just Melissa and the daughter. So all she has to do is just advise us of the cost add-on for the daughter, and he'll pay her half of that amount a month. Does that make sense?
You okay with that, Melissa?
Yeah. She says yes.
Okay, good. Two down. On the vehicle, one of the issues that you may have seen in the briefs that were filed, or maybe you haven't, Judge, and I don't blame if you don't because they were filed pretty late by both parties. But at the end of the day, we're going to distribute the money that's being held in the Mike and his partner split, and so Brandon Levitt, and they agreed on how they were going to divide up all the money. And we agreed in the term sheet that we entered on the date of mediation as to how that all was going to be divided. And so we're going to divide that money. Jack, can we agree that as soon as the decree or MSA is signed that Mike will write a check for her the amount? Does that make sense?
No. The thing is that he's already been given the operating account monies, and he's withholding them while he's at the same time deducting from her support other things. Our position is that under the agreement, when he received the money, she was supposed to get her share of it. He's just withholding it back, and he's shaking his head now because it's beneficial to him. But really, it's just applying undue pressure on her to withhold the money and say, you don't get any of it, and I get to honor the agreement that you're going to pay these expenses, but I don't have to honor the part of the agreement where I actually pay you the money that's yours. There's no dispute that it's her money.
Okay, this is a long way of saying no. I get that's a no. Mike, do you have any problem with just distributing the money now and accounting for it?
No. So what?
Okay, so we provided you an accounting. Jack, did you disagree with that?
Well, we haven't seen the final numbers.
You have the term sheet was provided to Mr. Fleeman's office from Snell and Wilmer, which identified any and all monies, which were confirmed yesterday in Mr. Fleeman's email, that he in fact did confirm the information that the monies were received were $270,958.90. That was in the term sheet from Snell and Wilmer. The other monies that have not been received pursuant to the term sheet as identified will be identified in the redemption agreement, which has not been received by myself.
So Judge, just so give you context here, Snell and Wilmer was the lawyers that represented Brandon. They did a lot of the paperwork, and that information was given to Jack. Now we agreed in the distribution that there was going to be a 33% holdback of those funds because of taxes. And we were just, sort of going back and forth on that, judges, this becomes an issue a lot of times in these cases where the money that's being distributed to the parties are pre-tax dollars. In other words, they're subject to tax already. In other words, these aren't like subject, we can give them to Melissa from the firm and say that they're her income. We can't do that. These are Michael's income, and he's going to get a K-1 for that, and he's got to pay taxes on it. Now, I even said in the email I sent back to Jack that I don't really know whether any of this will have a basis that they could use, like a capital account or some of this will be capital gains. But whatever it is to Mike is what he's going to pay tax on it, and that was the purpose for that 33%. We'll provide a full accounting of that through his accountant, and then Melissa will have that information and know they understand the amount that she's receiving and why.
And
So
if it's not all necessary, then it would be equally divided between the parties?
And that's in the term sheet, Your Honor, yes.
Yeah, right. So if there's no tax on it, let's say, for example, that Mike, for some reason, did not have to pay tax on those amounts, yeah, it would be whatever. The only amount that's going to be deducted from that 33% is whatever he has to pay in tax. If you don't have to pay anything,
Okay.
yeah, it'll
Then
be
they
divided
divide it.
equally.
Okay.
Well for that.
All right.
The issue
Just
that
a couple small deductions, though, Your Honor. One was off the top of that amount, the 278, 958.90. Melissa's going to get $20,000 to pay her fees, and Mike's going to give me $4,000 because Jack is apparently 5 times as good as I am. No, I'm joking on that. So, but in
Well,
any
I could be
event,
ornery and say y'all are both equally good, equally good looking too.
Oh. I like that. I'm
Well,
going
Bruce
for
was
that
on
at my
the
age.
case
Anything
What was that,
sounding like
Mr.
a top one of my looks.
Yeah, Mr. Cleveland, you
so-
started to say something a little bit ago. What was that?
Right. What I was saying is when we received the proposed MSA, part of it said, and it's standard language, and it makes sense because we're not tax experts and we don't give any tax advice.
Correct.
But the proposed MSA said that my client would have the opportunity to consult with a tax expert or a CPA to
Yeah.
go over the tax consequences. She did that, and they told her that she should not agree to that 33% holdback. So she didn't have professional tax advice prior to that. She was told, look, you should just get your share, pay your taxes. He should get his share and pay his taxes.
But it's
It just doesn't
her
work
name's
that
not on
way.
the business.
Right,
Yeah.
but I understand that. Today was the first time that Mr. Smith had pointed that out.
Yeah.
It's actually going to be income to him directly, so he's
Yeah.
going to have to pay the
Yeah,
tax.
he's going to have to be the one who's responsible for the taxes. So I agree with that, but there has to be a 100% accounting on what the taxes are, any deductions, and I know. I'm sorry, I know Mr. Flaxman well enough to know he's going to do everything he can not to give the government any more than he has to. So, Ms. Flaxman, I do know you'll get your fair share of anything that's left over.
That's for
And Your
sure.
Honor, there's been a separate account opened for safekeeping of those monies for
Okay.
payment of the IRS. So those have been separated and will be held in self-keeping.
Okay.
Perfect. And
All
then there
right,
was
as
some.
long, we just pretend like it's a trust account and you don't mess with it because then the state bar can come after you. Or in this case, this judge will come after you. Yes, Miss
I
Flaxman.
just want to make it clear because I think we.
Hang on, Miss Flaxman wanted to say something here.
I just wanted to ask that he not get any extensions on that next year.
Yeah, you need to file the taxes as soon as you could possibly get it filed.
They'll be filed in February, Your Honor.
Thank you.
The thing that I wanted to point out, I think we said it, but it kind of got glossed over a bit, is that the operating monies that he's received, less the 33%, should be distributed. My client's
Correct.
share should be
I
distributed.
agree.
I'm
That
okay
should
with
be
that.
as soon as possible.
Yeah, I'm okay with that. And then there was a couple of charges. The party's daughter had a little bit of surgery recently. She's okay, Judge, but she had a bill. I'm sorry?
It was just an echo on your end.
Oh, okay. So she's the surgery had some unpaid medical bills for UMC and the anesthesiologist. One was $625.10 for UMC, and then $243.22 for the anesthesiologist. And Mike paid those expenses. So Melissa agreed, I'm told in writing, that her one half of those expenses would be deducted from her lump sum. So the total amount of the payout from the operating agreement to Melissa will be $78,337.07.
You agree with that?
Yeah, the accounting is accurate, Your Honor. I mean, just with respect, and this is obviously a very weird situation as counsel who is being represented, but I haven't been withholding these monies. The term sheet it does not identify a date upon which those monies would be released. So it was completely silent on that. I am happy to go to the bank and have a cashier's check available for Ms. Flaxman to retrieve tomorrow.
Yeah,
Tomorrow's
good. So
Veterans Day, so let's do
resolves that
Friday.
issue.
Tomorrow's Veterans Day, so let's do Friday
Oh, right.
because you may
Can't
not
go to
have
the bank
time to
tomorrow.
make it to the bank.
That sounds
Friday's
good.
fine. It'll be available for her to retrieve.
All right. Thank
Okay.
you. Anything else?
Okay, then, yeah, a couple things, small ones. There was a vehicle that Melissa is going to take as her car. I don't remember what it was. Melissa can tell us, but it has an outstanding loan. Yeah, it has an outstanding loan balance of $25,5573 and a monthly payment of $451.87. But Melissa's indicated through Jack in an email this morning that if she gets the money from the distribution, then she'll just pay that off, and that resolves the next question, and that is we were going to talk about vehicle insurance because Melissa couldn't. The insurance was in Michael's name. She couldn't change that until after the amount was paid off. But if she's going to pay it off, then she'll be able to get her own policy. My only statement to Jack was that if I think the policy payment is due on the 20th, so Mike can make that payment, and then just Melissa can reimburse him for that payment if she can't get an insurance policy in time.
Okay.
Does that make
My only
sense?
question on the Nissan is if I give her a certified check on Friday, I don't believe that will clear in time for, it's probably going to be a 7-day hold because we use the same bank. If it doesn't clear, then we need to address the situation of who's making the timely payment for November.
Yeah, I think I just did, but I'll try that again. So
Okay,
I thought the
sorry.
payment was due on the 20th. And so if it is, Mike, just make the payment and Melissa will pay you back for whatever the amount is. Send her a copy of the check you sent or whatever. Okay?
All right. Yeah, because we don't need a lapse in insurance.
No, absolutely not. That'll be more, yeah, no, we don't need that. So Mike will make sure that that's
hold
paid.
on. Hold on one second. I want to see a smile from Mom. She's not smiled yet. There we go. I knew it had to be a beautiful smile. Thank you.
Well,
All right, so the personal effects, Your Honor, we had some difficulties over that, but now we've agreed that the way it works under the plan, and remind me if I don't have it in front of you guys, so if I get this wrong, just let me know. But the way the plan works, as I understand, is Melissa's going to go to the house. She's going to, without Mike being there, and she's going to look at all the stuff in the house. And then she's going to provide us a list of the things that she wants, or was it an A/B list? I can't remember.
The term
Not
sheet
A/B.
says an A/B list, Red.
No, it does not.
Yes, it does. Jack, if the term sheet specifically says create an A/B list.
Oh,
No, it
okay,
does
so
not.
let's do that.
No,
Let's do the
pull up
A/B
the term
list.
sheet, Brad.
What's that?
Pull up the term sheet. It doesn't say that.
I'm looking at the term sheet right here. It says she will create an A/B list.
Let me pull it up.
All right, let me pull
Let me pull it
it
up.
up. Hold on.
Well, I don't have it, so I can't tell you.
It's attached to
actually,
the, it's exhibit
we
1 to
submitted
our
this-
brief.
I'll read it exactly what it says. The parties shall work out the division of personal property. Wife will provide a list of her inherited and gifted property. Husband acknowledged all property given to them by wife's family was an inter vivos gift to her as her separate property. Wife will also provide a list of community personal property and designate what property she will take. Husband will arrange to allow wife to have access without his presence To inventory property at the home. Wife shall have all holiday decorations except the ballerina ornament. Wife shall have the American Girl dolls. Nowhere that says A/B list. It says she provide a list of what she would like to take. But
So
it's
if she
different
wanted it, under your interpretation, Jack, if she wanted every piece of stick of furniture in the house, she could take it. Is that right?
No.
But it's not an
It's
A/B
saying
list.
a list. She gets to provide a list of what she wants. It doesn't mean she gets
Okay.
it. She just provides a list of what she wants. I mean, if she goes through there and there's only like 4 or 5 knickknacks that she wants, I'm pretty sure Mr. Flaxman's going to say, okay, take it. But if she,
Yeah,
but
look,
if she
it-
does
it-
want every stick of furniture in the house, he's going to say, no, we're going to go do a trial.
Okay, I got you. Well, Judge, that'll help us. And frankly, I think Melissa's going to know what she wants. We actually talked about it briefly at the mediation, and I got a feeling it's not going to be that big of an issue. I know that there's a whole bunch of stuff that Mike would like out of the house. So, but anyway.
Well, see,
all right, so
I
that's-
want that little cabinet that's behind Michael right there. That's nice.
That's Melissa. So that's already been agreed upon.
All right.
Okay.
Okay, the other issues are, I think, resolved, Jack, unless you've got something about you wanted to.
Well, the other concern that my client had, Your Honor, and it's in our brief, and I'm not sure if the court had time to
I have
review
not.
it. Is that the support amounts that are in the brief were based, it says in the term sheet, and it was agreed upon that my client would have an imputed income of $35,000.
Yeah.
She doesn't make that. She hasn't made that in several years, but that was an agreement. The representation at the settlement conference was that Mr. Flaxman was going to work for Mr. Smith and that he would make $140,000 a year. He could make more depending on what he brought in or whatever the bonus structure is there. Within a couple weeks, Mr. Flaxman had already registered a business with Sean Goldstein and is believed to be in a partnership with him. I don't think he ever went to work for Mr. Smith. So understandably, my client is concerned that the $140,000 that he represented he was going to start making wasn't accurate and was a misrepresentation.
What was he traditionally making?
Judge,
I think
let
he was
me
making
just address this.
$180 to $200 a year.
For 2 years, he made more than that. But the reason the 140 had nothing to do with him coming to work for me, that was probably an estimate of what I thought he would make. But let me point out a couple things about this. Is that, one, the 140,000 was the precise income that was identified by Jenny Allen, I think it was, Mike, in her report.
Unimari.
Oh, that's right, Jenny Ordamari, in a report as the reasonable compensation of Mike. And since Mike was leaving a firm, he doesn't know that he's having any work whatsoever. My thing was an eat what you kill kind of deal, and I think his deal with I think it's Sean Goldstein is probably the same. So he doesn't know what his income would be. But you know what we did, Judge, to make sure that Alyssa felt comfortable, was we agreed that he would report his income to her every year.
Yeah.
Who does that?
Well, he'll report his income. Well, how long is the marriage? Since 2004. So this is a 17-year marriage.
Yeah. Well, she's got there was support, but all this played into the support. In other words, for example, there were other provisions in the agreement for him waiving her PERS, him agreeing to take the tax liability. That was all part of the overall agreement in which she took a little bit less time for the alimony, and that was all part of the mix. But to say that we represented that Mike would make $140,000 with me is just not accurate. It's misstated. He said that I thought he would make that amount, and he couldn't make more.
Yeah,
Couldn't make
but
less.
the one thing,
But,
the one thing that we all know, we cannot determine exactly what somebody is going to make, whether they work for someone or not. If they don't get the billable hours, they get fired. If the clients don't walk through the door, they get fired. I really think that $140,000 is a reasonable assumption of what he can make with his number of years of service and everything else like that. But if his taxes come back and he's only making $90,000 a year, I mean, we can either accept the $140,000 or every year that it fluctuates. If it goes down, the spousal support's going to go down.
Well, I'm talking a lot about child support too, Your Honor, and just getting the correct
And
amount.
child support will go down. I mean,
Right.
so he's going to provide her what he's going to be making every year. We'll make a determination every year if Mom wants to come back or if Mr. Flaxman wants to come back.
The term sheet in the agreement was that he would provide proof of income by April
Yeah.
every year.
So he provides
That's
it by
right.
April of every year, and we go from there. That should. I'm pretty sure he's not going to want the IRS to come after him, so it's going to be there on his taxes.
And
Well,
just to
so Judge,
sorry to
just-
interject, Your Honor, but part and parcel of the agreement was that an imputation of stated income to Mrs. Flaxman of $35,000,
Yeah.
which was far below her earning capacity with a master's degree in what she had previously earned. So these things were these things were all taken into contemplation when we came up with the agreement. I don't want this to be a one-sided affair.
It's
we
not.
misrepresented where I was going to work or what I was going to make. Because Ms. Flaxman could certainly make more than $35,000 a year with a master's degree with 10 years of service as a teacher.
Well, that's the dispute, isn't it? Is that there
Well-
was, we think that she could make more. She's saying she isn't going to make that much.
Well, one
they
thing-
think
one-
that he'll make more.
Yeah. One thing that
Just-
I know is her income is something that we could, if she returns as being a teacher, we can look it up online and see exactly what it is that she's earning. Every county employees and every teacher, their income is there.
Yeah.
Mom
Well, look,
can
at the
make
end-
as much as $80,000 a year. I know a couple of teachers that makes that. It all depends on how much she wants to volunteer for.
So that we
Well, look,
have
at the end of
the
the day,
record, since we're making records of what was discussed, is it was explicitly discussed that my client's not going to be going to work for the Clark County School District for her own personal reasons, and that was understood at the.
I can't, and I can't blame her for that at all. I'm just
Right.
sitting here. I know she's got an earning capability. She may choose to do it. She may not. But it sounds to me like she's been a stay-at-home mom. So it's going to take her a while to get back up to that point. Mr. Flaxman, you know that. You've represented. I'm pretty sure you've represented something like that to courts many times before.
Well, look, Judge, we don't, Mike has probably made every argument in the book. He's done this a while, and I've done it a while too.
Yeah.
But Judge, we made this real simple. We said we're gonna put figures on each party's income. They may be disputed, maybe not, but
Yeah.
they are the figures from which we will all take information associated with any adjustment to either spousal or child support. We're required to
and
do
that
that
sounds
on
fair.
child support.
Yeah.
And that's the way we'll do it. And Mike even went further than that and promised that, look, I'll give you my income every year. And just so we know how that procedurally works is every year, whether you file on time or not, this year he will because he's promised to do that. But let's say next year he waits and gets an extension like everybody else seems to do. But on April 15th, he has to report what his estimated income is to the IRS and pay the estimated taxes on that date.
Yeah.
So it's not as if you can wait until October just because you file an extension. So just wanted that to be clear. And I think that issue now being resolved, that's it. Unless you've got some.
Yeah,
The
I
thing
mean,
that I
all
wanted
we
to
can do
point
is, this is just one of those things that we can only take it 1 year as it comes.
Okay.
Okay, we just take it every year, and, if I have to hear it every year, I hear it every year. Well, at least for 5 more years. Don't know what's going to happen after that.
You'll be fine.
Okay, thank you.
So, Radford, the only other thing I wanted to address on the visit next week for the personal property, because we haven't decided on any personal property division other than what is her what has been gifted to her.
Hey,
by the family.
guys, I've got a 3:30 child interview. This was only supposed to take about 15 minutes, so we've been at it for almost 40 minutes.
Judge, we appreciate your time, and I think we can work that out, Mike. Look, Melissa's not going to take anything from the house unless she's given us her list, and then after that list, we'll make arrangements. Same kind of arrangements for her to come and get it. She'll need a mover or whatever she needs, and then that'll be the end of it.
All right.
Well, I would like her to be able to take her clothes and personal effects. She
No,
asked for
she
winter
can't
clothes
have
previously.
that. No, I'm just joking.
Yeah,
Okay.
the clothes and personal effects, Mike, you don't have a problem with that, do
Yeah.
you?
No, she had a month to take it already, and she already has
Okay,
taken
the
all.
answer
I
is
don't
no,
wanna
you
hear
don't
that
have a
today.
problem with it?
We're doing good. I need it.
Bye,
but-
guys.
All right.
Thanks.
If you need my
Bye.
help, call my staff, and I'll set something up for y'all.
All right, appreciate it. Thanks,
Thank you.
Judge.
All right.
All right, bye-bye.
Redford doesn't motor.